I want to start with something that might feel uncomfortable. Waiting in a family court case is not neutral. I know that's what you've been told. You've been told to give it time, let things settle, don't escalate, be the reasonable one. And there's a version of that advice that makes complete sense. In the first days after a relationship breakdown, yes, a cooling off period can help, but there comes a point. And it's earlier than most fathers realise where giving it time stops being patience and starts being something else. I want to explain how this actually works, not just the outcome, the legal process that turns waiting into a problem. Because once you understand how it works, the decision becomes clearer. Let me describe what I hear from fathers when they come and talk to me. It usually sounds something like this. I've been giving her space. I don't want to make things worse. My solicitor told me to wait and see. My parents say give it time. And honestly, I don't want to be the kind of person who goes straight to court. I'm trying to be reasonable. And I want to be clear, that instinct is not wrong. The desire to de-escalate, to preserve whatever informal contact still exists, to not throw petrol on an already difficult situation, those are reasonable instincts. And in the right circumstances, they are the right call. But here's the thing that doesn't get explained clearly enough. While you're being reasonable, while you are giving it time and not making it worse, something is happening in the background, something that has nothing to do with your intentions, everything to do with how a family court will eventually look at your situation. When a family court is asked to make a decision about where a child lives and how much time they spend with each parent, it does not start from zero. It starts from what is already happening. The court looks at the current arrangement, whatever it is, however it came to be, and that arrangement becomes the baseline, the starting point, the thing that has to be justified to change. This is sometimes called the status quo principle, and it exists for a reason. Courts do not want to unsettle children's lives unnecessarily. A child who has been living in a particular way for a year has routines, a school, a social context. Disrupting that requires justification. So far, that seems reasonable enough. Here's where it becomes a problem for fathers. The current arrangement, the one the court will use as its baseline, does not have to be a formal arrangement, does not have to be fair, does not have to have been agreed. It just has to be what is currently happening. So if your ex has been limiting contact for 6 months, even if she has done that unilaterally, even if it began as a temporary thing after a difficult week, even if there was never any discussion about it, that 6-month pattern is now part of the picture the court will see. And the longer that pattern runs, the more weight it carries. Let me give you a specific case. I'll give you the facts only, no names, no identifying details. A father of 4, separation was difficult, contact began to break down, the mother made allegations, false ones, and those allegations led to court proceedings. Among the allegations, cameras the father had installed as nanny cams were framed as surveillance devices. A court made findings against him, findings that were later challenged, but at that stage, they stood. The proceedings became protracted. Every hearing produced delays, requests for reports, extensions, rescheduled dates, and during all of that, during the months and then years of the case, life continued. Contact was slowly rebuilt. Overnights were approaching, things were moving in the right direction. Then a new allegation was made. Inappropriate photographs of the children on a father's iPad. Family photographs, a paddling pool, a warm afternoon, children playing in the water, normal family life, documented on a phone. Police were called, and an investigation began. It lasted over a year, and at the end of it, no further action. The photographs were exactly what they appeared to be. But here is what happened during that year of investigation. The mother had given notice to the tenancy in Richmond. She had moved with the children to Kent. She had told the court she would maintain the children's school transport from the new address. She did not. The children moved schools. They made new friends, they found a new routine. By the time the final hearing arrived, the court was looking at a different picture entirely. Children settled in Kent, new schools, established routines, a year of that being their life. The father's position, this relocation happened during disputed proceedings. It was not agreed. It should be reversed. The court's position, the children are settled. Moving them again would be disruptive to their welfare. The father had done nothing wrong. He had fought every allegation. He had waited for the investigation to clear him. He had trusted the process. And the process had produced an outcome that nobody would have predicted at the start. Here is what the case taught me, and it changed how I work. Delay itself is a form of outcome, not because the system is broken, but because the system is doing exactly what it is designed to do, protect children from disruption. And when a situation that began as a dispute calcifies into something how things are, the system will protect that too. Let me make this concrete. Contact broke down 3 months ago, you're early. An application now gives the court a situation in flux. There is no settled pattern yet to protect. If it's been 6 months, the current arrangement is starting to look established. An application is still absolutely the right move, but the court will now be thinking about whether changing things would be disruptive. If it's been a year or more, and this is where I see the real cost of waiting, the current arrangement has been the child's life for a significant period. Whatever it looks like, the court will not ignore that, and an application to substantially change it faces a much higher threshold than it would have faced earlier. This isn't about pushing you to act before you're ready. It's an accurate description of how this works. Let me be clear about what I'm not saying. I'm not saying you should rush into an aggressive court application the moment things go wrong. Mediation first, where it's viable, is definitely the right approach, and the courts expect it. I'm not saying legal action is always the answer. It's definitely not always the answer. What I am saying is this: the decision to wait is a decision. It has consequences that run in one direction only. The time you spend waiting does not come back, and the pattern that forms while you're waiting becomes the starting point for any future application. The fathers I've seen get the best outcomes are the ones who understood this early. They were not the most aggressive or the most litigious. They were the ones who stopped treating time as neutral and started treating each week as a decision. Here is what I want you to take from this. First, the status quo principle is real. Courts look at what is already happening, and the longer a particular arrangement has been running, whatever it is, however it came about, the more entrenched it becomes as the baseline. Second, the cost of waiting is not just emotional, it is legal. It affects the threshold for change. It affects what a court will be willing to disturb. Third, acting early does not mean acting aggressively. It means understanding that time is not neutral in this process and making a deliberate, informed decision about what to do with it. If you want to understand what taking action actually looks like, the specific steps, the timeline with what each stage of the process involves, the next video walks through that exactly. Links below when it's live. Subscribe if this is useful. And one question before you go: how long has contact been disrupted in your situation? Drop it in the comments. I do read them, and it helps me understand what to cover next.